Good day to you all. Welcome to the second lecture of Shipmaster Law and Business lecture series. Today we'll discuss about torts. Let's begin. What is tort? Tort is a legal term that refers to a civil wrong that causes harm or loss to another person, for which the injured party may seek compensation through a lawsuit. Right? These damages may be sued in a civil court. Let us take an example. A vessel ran aground due to poor navigation and inadequate watchkeeping of the officer of the watch. So in that case, the ship owner owes duty of care of their ship from the officer of the watch, but officer of the watch didn't perform the given responsibility, so it's a civil wrong, and the ship owner may file a lawsuit against the officer of the watch, and he will be judged as per the tort law. Purposes of the tort. So the purpose of the tort law is to provide a legal framework for resolving disputes involving harm or injury caused by one party to another. So let us see. The main purpose of the tort is to provide compensation to the injured party. The second purpose is the deterrence. What is deterrence? Deter individual or organization for committing harmful act. Right. So this tort law will deter like any individual or any party to do any harm to the other party. We said that it ensured justice and fairness, and finally it gives vindication of rights, right? So it protects individual rights and provide a remedy. So there are different type of tort in the maritime industry. The first type is called negligence. The second type is intentional tort, and last but not the least is strict liability. We'll see each of the type of tort in the following lectures. What is negligence? A negligent tort is a type of civil wrong that occurs when a party fails to take reasonable care, resulting in harm or injury to another party. So suppose you are a cargo owner, you have loaded some cargo on a ship, and due to improper stowage, your cargo is damaged, right? So as a carrier, um, the carrier owes a duty of care to the cargo owner, and if the crew fails to properly monitor or maintain cargo condition resulting in damage, the cargo owner can sue for the damage, right? So it happens very commonly in our onboard ship and in the maritime industry. So in that case, the cargo owner will get compensation under the tort law. There are different elements of negligence. There are the 5 basic elements of negligence. The first element, we call it as duty of care. What is duty of care? The duty of care is the defendant owed a legal duty to the plaintiff, right? As a officer of the watch, you have a duty of care to follow the code reg, right? Then we have got the breach of duty. What is breach of duty? The defendant breached that duty by acting carelessly or failing to act, right? So what is that? So suppose you are given a responsibility to do a officer of the watch job in a certain time, like from onboard ship, maybe from morning 8 o'clock to 12 o'clock, and you are supposed to do your duty as officer of the watch as per the STCW. But instead of that, what you did, you just watch the mobile phone during that time, and actually due to that you have breached the duty, right? So that is called the breach of duty. Then you have got the causation in fact. What is causation in fact? The defendant breach actually caused the harm. So you have watched the mobile phone, and due to that, due to your carelessness, what happened? The vessel has grounded or collided. So due to your negligence, what happened? Actually, a harm happened to the ship owner. So that is called the causation in fact. Then proximate clause. What is proximate clause? The harm was a foreseeable consequence of the defendant action, right? So yes, if you watch mobile phone during your duty time, obviously you may end up in grounding or collision or any other damage to other vessel, right? So that's why this cause, watching phone or being negligent in your watch time, is called the proximate cause. Damage, and obviously the plaintiff has to suffer actual harm or loss, right? Let's take that example. As you have watched the phone, the vessel has grounded and the ship owner has suffered an actual financial harm and physical harm of the ship, right? So these are the 5 key elements of negligence. So if someone want to claim and something compensation on the negligence, then obviously you have on the court, the plaintiff has to make sure that this 5 element is present in the negligence, right? Then you have got another type of tort, we call it intentional tort. Then what is intentional tort? An intentional tort is a civil wrong that occurs when somebody or someone deliberately causes harm to another person or their property, right? So the key feature of intentional tort is act is intentional, it is not accidental or carelessness. I can give an example, like intentionally you have trespasses someone's property, right? So that act is intentional, and if the plaintiff or the other party want to sue you, he can sue you under intentional tort. Harm can be physical, emotional, or reputational, right? So let us take an example, you have maybe you have given a very bad review, intentional bad review, uh, um, to a company which is a reputable company, and you have done it to cause harm to that company. So in that case, the company can sue you under the intentional tort. The victim can sue for compensation even if criminal case is also filed. So if the plaintiff or the victim, he files a case in the criminal court for to get the damages or compensation, he file a case under the civil court as well, right? So for criminal case, you may get like some jail or penalty, whereas in the civil court, you'll the victim will get the compensation under the tort law, right? So the unlike negligence, intentional tort don't require to proof of carelessness, right? Just prove that the harmful act was done on purpose, right? So in the civil court, they have to prove that the victim has to prove that it was done on purpose, right? Let us see some common example of intentional tort. We have got in the intentional tort, we have got assault, battery, false imprisonment, trespass to land, defamation, intentional infliction or emotional distress, right? So what is assault mean? The assault mean the threat of immediate harm or offensive contact, right? So let us take an example, right? Raising a fist to punch someone, right? So you don't like someone, you just punch someone, right, on board ship. So it is called assault. Battery, unwanted or harmful physical contact, right? Right, you just slap or punching someone, right? So that is called the battery. False imprisonment, unlawful restraint of someone's movement, right? Locking someone in a room without consent, that can be an example of false imprisonment, right? So you don't like anybody on board ship, you just locked him in a room without his consent, right? You cannot do that. So that is called the false imprisonment. Trespass to land, entering another's property without permission. So you just walked into someone's garden without consent, right? So that is not that is the trespass to land. So on board, sometimes what happens as a seafarer, we go to different port, and there is written that no unauthorized access on the port area, right? Then also what we do, uh, out of curiosity, we just walked in without taking consent to that restricted area, right? So the port authority can sue you for that trespass to land, right? Defamation, damaging someone's reputation through false statement. Publishing for the example can be publishing false rumors online, or posting false review in the Google, right? These are all are under defamation. Emotional distress, extreme or outrageous behavior causing severe distress, right? Like the example can be bullying someone with repeated threats, right? What we do very commonly on board ship, right? So if we don't like someone on board ship, previously it used to happen, right? So if you don't like junior officer or cadet, you just bully him, right, with repeated threat that okay, uh, uh, that is not good, right? And that can fall under emotional distress or intentional infliction, right? So these are the common example of intentional tort. Strict liability, there is the third type of tort. What is strict liability? Strict liability is a legal doctrine under tort law where a person or entity is held responsible for harm regardless of fault, intent, or negligence, right? The key feature of strict liability is no need to prove negligence or intent. The focus is on the nature of the activity or product involved, and the defendant is liable simply because of the activity or product is inherently dangerous or defective, right? Suppose you are carrying benzene and that benzene causes lung cancer, right? If you don't load it in an enclosed environment, what happens? The benzene fume will go out and it will harm the people around the ship, right? So the the victim can actually um, claim for strict liability, claim for compensation under strict liability, right? So this is the example of strict liability. So let us take some common example of strict liability, like product liability. Injuries caused by the defective or dangerous product. There is the product liability. So a faulty airbag explodes and injures the driver. So in that case, the driver can actually sue the airbag company for giving the faulty airbag, or can sue the car company for giving the faulty airbag. Abnormally dangerous activities, high risk activities that cannot be made safe even with precaution, right? Example can be blasting dynamite near a residential area, right? So you cannot you cannot blast a dynamite near a you should, if you carry some dynamite, obviously you have to have proper protection to carry the dynamite, right? You cannot blast the dynamite near a residential area. In that case, the people in the residential area can sue you for blasting the dynamite. Animal liability, harm caused by the wild or dangerous animal kept by a person, right? So right, you have got a pet tiger, and which one escaped and injured someone, right? In that case, the victim party can sue you under strict liability, right? Or you have a dog which is ferocious, and you just kept him open and he just escaped from you, and he may be that dog may bite somebody else. In that case, the victim can sue you uh, and can get some compensation under strict liability. Occupational hazards, a strict rule applies to in high risk industries. In that case, you need to follow those strict rules regulation, right? So as I've given example, like benzene, right? So as you're loading benzene, which is very toxic and which is injurious to health and which causes lung cancer, in that case you need to do close loading on board ship. If that benzene fume releases and it harms someone on board ship, and maybe in the port, the person in the port or onboard ship, they can get ask for compensation under strict liability, right? So here I have given a comparison table between all the torts. The first one is negligence, the second one is intentional tort, and third one is strict liability. Let us see. Here on the left hand side, I put the aspect, right? So what is the definition of negligence? Let us recap again. Is a failure to exercise reasonable care, that is called the negligence. Whereas intentional tort, it is a deliberate act, right? And strict liability is the liability without fault for inherently dangerous act, right? So there is the definition of three types of tort. Intent, for negligence, you have to prove that the person uh, he was careless, whereas in the intentional tort you have to prove that the person was doing unlawful things intentionally, right? Well, willfully. Whereas in the strict liability, it is irrelevant. Carelessness or intentional is irrelevant. Is liability imposed regardless of intent, right? So it is very much fall into the types of the product, right? Key requirement. Here in the negligence, you have to prove duty, breach, causation, and damage. In the intentional tort, you have to prove that it was done intentionally. Whereas in the strict liability, prove harm, that activity, product was inherently dangerous or defective, right? Example, we have already discussed the examples. And in the negligence, the liability based on the breach of duty, whereas in the intentional tort, liability based on the intentional conduct, and in the strict liability based on the nature of activity or defect, right? Hope this comparison table will help you to understand the tort better. Let me know if you want to know more about tort in the comment box. We can discuss more. See you in the next lecture. Thank you very much.